Sorry, everybody. We will wait to begin the meeting because we have. Alors bonjour, bonjour à.
Good morning, everyone. Welcome to meeting number 45 of the Standing Committee on the Status of Women. Today, for our first hour, we will be continuing our study of sexual harassment in the federal workplace. And in the first hour, we have with us the Department of Human Resources and Skills Development, Ms. Caroline Cyr, good morning, and Ms. Judith Buchanan. Excuse me, I got it wrong in French. Welcome. We also have Elizabeth McPherson from the Canadian Industrial Relations Board, who's appearing from Toronto by way of video conference. So this is how we'll work. Each organization will have 10 minutes, and then we'll go to the question and answer period. So we'll start with the Human Resources and Skills Development Department. 10 minutes. Thank you very much.
Today on behalf of HRSDC and the Labour Program. The Labour Program administers the Canada Labour Code, which covers labour relations, that's under Part 1 of the Code, occupational health and safety, which is Part 2, and labour standards, which is Part 3 of the Code. And it does so for federally regulated private sector employers. For Part 2, it's important to note that we have extended jurisdiction, and so we also cover the federal public sector, while Part 1 and Part 3 do not. Today I want to focus my opening remarks on how occupational health and safety regulations and labour standards obligations address sexual harassment concerns in the workplace. Both occupational, much better with the glasses, I've got to tell you. Both occupational health and safety and labour standard obligations are a shared responsibility between the Labour Program and employers, and that's an important point. The Labour Program sets the legislative and the regulatory framework for employer policies. We educate workplace parties, and we enforce the Canada Labour Code requirements via inspections and handling of complaints. Employers are responsible for complying with the requirements of the Code and for administrating workplace policy. And in this case, it's the policies that address violence in the workplace and sexual harassment. This includes investigating and responding to incidents of violence in the workplace, as well as allegations of sexual harassment. As it pertains to occupational health and safety, the Canada Occupational Health and Safety Regulations, which were introduced in 2008, establish a regulatory framework for violence prevention in the workplace. This applies to federally regulated workplaces, including the federal public sector. In the case of the Federal Public Service, the Treasury Board policy on harassment prevention and resolution incorporates these regulations by reference. And I understand that Treasury Board was in front of the committee last week, so I know that you've heard from them about their policy. Workplace violence is defined as any action, conduct, threat, or gesture of a person towards an employee in their workplace that can reasonably be expected to cause harm, injury, or illness to that employee. While this policy requirement has a broader application to address bullying and other types of aggressive behavior in the workplace, it can also be applied to sexual harassment toward an employee. In establishing a violence prevention program, an employer must consult with its Workplace Health and Safety Committee, which is comprised of employee representatives, and assess the workplace to determine the potential workplace violence issues. The workplace violence program does not need to address sexual harassment specifically and focuses more broadly on all forms of workplace violence. In addition, each employer must develop and post a workplace violence prevention policy, and this should include a commitment to providing a violence-free workplace and a statement that bullying, teasing, and abuse and other aggressive behavior will not be tolerated. It also has to include an indication that the employer will share any information concerning the factors which contribute to workplace violence, assistance for employees who have been exposed to workplace violence, and finally procedures to follow should an employee be subject to workplace violence. Employees also have a responsibility in creating and sustaining a violence-free workplace. They're to report cases of violence to the employer, who's responsible to record and investigate the act of violence. And it goes without saying that they must abstain from violence or be subject to disciplinary actions. It's important to know that Part 2 of the Code does not require employees to inform the labor program of any employee complaints of violence in the workplace, including sexual harassment. They are responsible to deal with any such complaint, and should an employee not be satisfied with the results of the employee's investigation, then they can file a complaint with the Canadian Human Rights Commission, who I understand was also presenting in front of the committee last week. I'll now turn to Part 3 of the Code, which establishes an employee's right to employment free of sexual harassment and requires employees to prevent sexual harassment in the workplace. This applies to federally regulated workplaces, but does not cover the public sector. In comparison with the Federal Public Service, federally regulated workplaces are required to have a policy that addresses sexual harassment specifically, while the Treasury Board policy on harassment prevention and resolution addresses all types of harassment. The Code defines sexual harassment as any conduct, comment, gesture, or concern of a sexual nature that is likely to cause offense or humiliation to any employee, or that might on reasonable grounds be perceived by that employee as placing a condition of a sexual nature on employment or on any opportunity for training or promotion. Every employer, after consulting with employees and their representatives, must issue and post a policy on sexual harassment. The policy must contain a definition of sexual harassment, a statement entitling employees to employment free of sexual harassment, a statement specifying the employee will make every reasonable effort to prevent sexual harassment, a statement confirming that the employee will take appropriate disciplinary measures against any person who subjects any employee to sexual harassment, a statement explaining how complaints of sexual harassment may be brought to the employer's attention, a confidentiality statement, and a statement informing employees of their right to seek redress under the discriminatory practices provisions of the Canada Human Rights Act. The compliance activities under the Code with respect to both sexual harassment and violence prevention in the workplace range from proactive counseling to inspections to reactive investigations of employees' complaints, and finally, as a last recourse, to prosecutions. The labor program utilizes inspections as one of the program activities to ensure employers' compliance. In cases where violations are noted by the inspector, employees are encouraged to voluntarily comply through education and counseling. Under Part 2 of the Code, a labor program officer may direct an employer to comply with the regulatory requirements for a violence prevention program. In accordance with provisions of Part 2 of the Code, an employee may submit a complaint to their employer using the internal complaint resolution process, which promotes the internal resolution of complaints by the workplace parties. Only unresolved issues with respect to the implementation of the violence prevention program would be reported to the labor program for investigation. Under Part 3 of the Code, an employee may file a complaint with the labor program alleging that the employer has not developed or posted a sexual harassment policy in the workplace. The complaint would be investigated, and all attempts would be made to educate and counsel the employer with the goal of obtaining voluntary compliance. Under both Part 2 and 3 of the Code, individual complaints of sexual harassment are referred to the Canadian Human Rights Commission to be addressed under the discriminatory practices provisions of the Canadian Human Rights Act, as they are the primary authority to address discrimination in the workplace. The labor program has received some complaints where employers were not compliant with the violence prevention regs and sexual harassment provisions of the Code. These mostly related to the lack of policies, and in all cases, employers were able to correct the situation and comply with the Code. Over the last 5 years, from 2007 to 2012, the labor program received 2 complaints only with respect to sexual harassment provisions under Part 3 of the Code, and both complaints were unfounded. The labor program, in conclusion, strives to create Canadian workplaces where trust and respect for everyone are the norm. We're committed to protecting the fundamental right of workers and employers to work in an environment that is safe and free of violence and sexual harassment. Thank you.
Je vous remercie beaucoup.
Thanks very much. We go now to Ms. McPherson. You now have the floor, 10 minutes.
To thank the committee for allowing me to appear by video conference. That's much appreciated. I'm the chair of the Canada Industrial Relations Board, which is responsible for the administration, interpretation, and enforcement of Part 1 of the Canada Labour Code. Part 1 governs the relationship between unions and employers in the federally regulated private sector, and Ms. Cyr has already given you an indication of what that federally regulated private sector encompasses. Under Part 1, the Board hears applications and complaints related to the acquisition and termination of bargaining rights, unfair labor practice complaints, the maintenance of activities that are essential to public health and safety in the event of a work stoppage. We very rarely hear any cases directly related to harassment of any kind, let alone sexual harassment. The only way in which those cases tend to come before the Board are in respect to an obligation that unions have under the Code to fairly represent all of the employees in a bargaining unit. The union is obliged to act in a manner that is not discriminatory or in bad faith or arbitrary. I had a survey done of the cases since the amendments to the Canada Labour Code.
Excusez-moi, Madame McPherson.
Excuse me. I've just been told that there's no sound in our meeting room. I think we've got a technical problem here. I would ask you to just wait for a moment, if you would, please.
Yes.
We can hear it but not in the room.
Everybody can hear?
Est-ce que tout est bon? Ce serait pas long, il fallait. Mais tout le monde, c'est pas tout le monde qui a des écouteurs.
OK, on va faire un test. Pouvez-vous juste...
We'll do a little test. Could you just say something? See if we're getting the sound?
My presentation, or should I begin again?
Try again.
Oui? OK.
Just speak a little bit more if you would, please. We're still doing our test here.
Certainly. Did the committee... We thought we were making progress because earlier I was connected to the wrong committee.
Non, vous n'êtes pas dans le mauvais comité. You are in the wrong committee.
Parce qu'on suspend pour suspend que c'est à télévisé, donc
Alors, on va suspendre.
So we're just going to suspend for a couple of minutes here and see if we can work this out.
What's the problem?
If everyone takes... We're very sorry about these technical difficulties. Go ahead.
I wanted to thank the committee for allowing me to appear by video conference, but I regret the difficulties that has occasioned for the committee. As you know, I'm the chair of the Canada Industrial Relations Board, which is the body responsible for the interpretation and the enforcement of Part 1 of the Canada Labour Code. Part 1 deals with matters such as the acquisition and termination of bargaining rights, unfair labor practices, and the maintenance of activities that are essential for public health and safety in the event of a work stoppage. So our duties mainly revolve around the relationships between unions and employers. It's very rare that we would have a case involving harassment or sexual harassment coming in front of the board. Those kinds of complaints may and very rarely do come to us peripherally as part of a complaint against a union that would be filed under the duty of fair representation provision of the code. That section of the code requires unions to act in a manner that is not arbitrary, discriminatory, or in bad faith with respect to their representation of the employees vis-a-vis their rights under a collective agreement. I caused a study to be done of the jurisprudence of the board over the last dozen years or so, and we were only able to find about 30 cases where an individual had complained about the way their union behaved with respect to allegations of sexual harassment. And interestingly enough, the majority of those complaints were from the harasser, who was complaining that the union didn't do enough to defend him or her against the allegations of harassment. There are some cases where an individual who was harassed complained that the union wasn't doing enough to represent them. And of course, those are the kinds of cases that the board would hear and determine. But as I say, it's very rare that we have any involvement whatsoever in the subject matter of your inquiry. I'm quite prepared to take any questions you may have.
Merci beaucoup, Madame McPherson.
Thanks very much, Ms. McPherson. Okay, now we'll go to the question and answer period. We'll start on the government side. Yes? did you raise your hand? You raised your hand. Excuse me. Mr. Pay, so please go ahead. You have 7 minutes.
Coming today for this important study. We really appreciate learning more about each individual area. My questions are for HRSDC and the labor officials, so Carolyn, maybe it may be you. You indicated in your opening remarks that there's an education component on occupational health and safety and labor standards as they pertain to workplace violence, and that includes sexual harassment. Could you elaborate on that end and explain to the committee a bit more the types of training and education that are provided on these standards and who's responsible for that training? Like, are the employers primarily responsible to ensure that the employees receive training and are properly educated, or like who does that?
It is a shared responsibility, and I would tell you that the best way to define how you divide those responsibilities and how we use the training and how we define educate and counseling. When it comes to the actual training component, the training of the employees, it falls within the responsibility of the employers, whereas the educational piece falls within the labor program. Now, I'll go a little bit more into more details for each of those elements.
Sure.
So the employee's responsibility, the employer has a responsibility to educate their employees with regard to what is acceptable behavior in the workplace. The responsibilities are a little bit different under Part 2 than under Part 3, so I'll present them separately. Under Part 2, which is the occupational health and safety component, in accordance with the violence prevention regulations, all employers in a workplace unit must receive training from their employer in any skills that would allow them to identify, prevent, or avoid any workplace violence, and that can include sexual harassment, as I mentioned earlier. The employers must provide employees with the information, the guidelines, and the training at least every 3 years as a minimum that's in the legislation. Training and education are essential when we strive to have a workplace that is free from violence and sexual harassment. Now, under Part 3, the employer is responsible for providing a workplace that's free from sexual harassment, and I defined that earlier in my presentation. So the employer has to make every reasonable effort to maintain a workplace that is free of sexual harassment, and that often involves ensuring through their policy that they can provide the right information and the right training to their employees. With respect to what the labor program's responsibilities are, we provide education and counseling to the federally regulated employers, either upon an employer's request to do so or as part of our duty to inspect the workplaces. During our inspections, the officers will explain the requirements of the regulations. We'll share the available tools, such as pamphlets, which can provide an overview of the provisions in question. And in some instances, we have what we call IPGs, Interpretation, Policies, and Guidelines documents. And if we have them, then these are brought to the attention of the employer to comply with. As an example, under the violence prevention, the labor program has created a guide that I'll be happy to provide you a link to that's on our website, which is meant to assist employers, members of a policy or workplace committee, health and safety representatives, in preventing violence in the workplace. The guide outlines very practical procedures, almost like a step-by-step of how do you comply with the requirements of the code, so that they can follow those instructions in implementing the prescribed steps for the prevention of violence. It includes the step of providing employee training and education.
Thank you, Caroline. My next question would be based on a couple of things you said. Well, one of them was, I think you said every 3 years. They have to train, I think, every 3 years?
To refresh, yeah.
To refresh. So there's no training whatsoever for an entire 3 years. So if you're new, you get trained, and then nothing else happens for 3 years?
The policy is always has to be posted and visible. It doesn't mean that there is no training. The minimum requirement set by the code is every 3 years. It's up to employers to decide if they want to increase the frequency of that. And of course, when you have new employees that come into the workforce,
Right.
they would be either through an orientation program or they would be informed of what's available.
So when you were speaking earlier, you mentioned that the employers develop and publicly post their violence prevention strategies. How do we ensure that these strategies in the workplace are working? So if they're developed by an employer and posted, how do we know for sure that the employees are aware? Is there some type of follow-up done to ensure that the rules under the code are being followed by the employers with respect to the policies? Like, is there some type of accountability?
We do follow-ups. That is part of our compliance activities. We'll do follow-up either through proactive measures, so through inspections, or through a reactive measure. If we receive a complaint from an employee, then we'll do an investigation. And we will verify during both inspections or investigations whether the code was, the provisions of the codes were adhered to. In terms of some data, since 2008, when the provisions under the violence prevention regs were introduced, the labor program conducted about 700 inspections, with a goal specifically of ensuring that the employers' violence prevention programs are indeed developed and functional. Now, there's almost, I believe it's 9,300 employers in the federal jurisdiction, so obviously we can't visit them all in 1 year.
Sure.
So we have what we call an intervention model, which enables us to target high-risk industries, such as the road transport sector. So we'll target our inspections in those areas first and foremost to ensure that indeed the policies are adhered to.
Is the inspection system complaints-based? Oh, we're done?
Madame Toupé. Merci.
Thanks.
Thank you. Time's up. We'll go to the other side. Ms. Ashton, 7 minutes.
Just actually wanted to follow up on your last comment, Ms. Sear. You mentioned the rail industry being a high-risk industry. Is that in the context of harassment in general?
No, it's in the context of overall. When we look at our data in terms of how many, if it's under Part 2, how many hazardous occurrences, fatalities, investigations. Under Part 3, how many investigations we do. We then determine which one are the high-risk industries.
Okay. Thank you for that. And I'm wondering if you have an idea of which sectors or workplaces might be high risk in terms of sexual harassment.
Because we don't collect data specifically about sexual harassment, we're not able to provide you with that response. The data collection that we have is specific to what our intervention activities are. So if we go into a business or a workplace to do an inspection or investigation, we'll record that. With respect specifically to the violence prevention, we don't record the type of violence, so we don't keep data on that. So we don't have what we do have is we can tell you how many inspections we've done, how many complaints for violations under the violence prevention, but beyond that, we don't have any breakdown.
Okay, well, it follows suit from actually our presentation from Treasury Board last week, which also doesn't have data on how much sexual harassment occurs in the federal workplace. And while a figure of 29% was made in terms of general harassment complaints, there's actually no question to ask how much of that is sexual harassment. And when we're talking about something as serious as sexual harassment, obviously one would hope that the information would be available at anyone's fingertips. Is HRSDC working at asking that question and recognizing, much like the recognition exists in terms of hazardous occurrences, is there an interest in finding out exactly what kind of harassment takes place in certain workplaces, and specifically sexual harassment?
Our mandate under both Part 2 and Part 3 are very specific, and so we keep data that is in line with with what we're mandated to do under the legislation. So we have data with respect to the number of occurrences where we've been pulled in. An important point of clarification is that the employers, we provide the legislative and regulatory framework, and we provide the education and counseling, but it's up to the employers to ensure that they comply or adhere with the code. As part of that division of responsibilities, there's nothing in the code that mandates the employers to report back to us when there is violence in the workplace or where there are complaints of sexual harassment. That information never comes back to us. So even if we had data, it wouldn't be indicative of the whole universe because we don't know, the employees don't have to tell us what's happening in their workplace.
Okay, thank you for that. And that seems to be a gap that certainly, I mean, our committee's in a position to recommend how we could deal with such gaps. I'm wondering I want to move a bit to the question of the current times in which we're in, and specifically in terms of Human Resource Development Canada. In September, 1,700 more jobs were lost in HRSDC alone across the country, and I mean we've talked a lot in this committee about culture, prevailing cultures, and how in the federal workplace and how they might assist in both harassment taking place, but also or people's choice not to report harassment. And I'm wondering if in the context of job stress and workplace adjustment, if you have a sense of perhaps not just specifically sexual harassment, but perhaps the occurrence of greater stress on workers, and maybe a sense that they don't want to come forward with any harassment that might be taking place.
Unfortunately, as the labor program, we are the regulator, but we don't have that. That information falls within the purview of the employers. I think that Treasury Board Secretariat, as the employer, you mentioned specifically the public service cuts. So Treasury Board, as the employer of all public servants, would be in a better position to be able to answer that question. It falls outside of the purview of the labor program.
Sure. And how about in terms of applying the kind of work that you do with respect to HRSDC employees working on the ground in Service Canada offices and potentially some challenging situations, particularly in the current times we're in with respect to the cuts to EI, pension changes, that kind of thing. I happen to know people that work for Service Canada and wondering about the kind of situations that they're facing, and how in fact HRSDC might be responding to perhaps increased stress and potential for harassment.
Right. So again, HRSDC is, even though we are HRSDC, the labor program also regulates HRSDC the same way that it would regulate any other federal department. So in that respect, we would take the same role vis-a-vis our own department. The department is responsible for ensuring that they comply with the elements of the code, which means that they have to have a policy. They have to be able to, with respect to violence in the workplace, as part of their responsibilities, they have to be able to identify any of the factors that may come at play in increasing the risk of workplace violence. That would be work that's done by each of the employers, whether that's HRSDC or whether that's a trucking company that crosses borders. So it's up to the employers to be able to do that, but that certainly falls within their roles and responsibilities. And ours is to ensure that when we do inspections, that they have those policies in place, that they're posted, that the training has taken place, for instance, or if we receive complaints, that we can make sure that indeed they were in compliance with the elements of the code. If we receive complaints about sexual harassment, we don't actually...
Going
to have to interrupt you here, Ms. Zia. Thank you very much. We'll go now to Ms. James. 7 minutes.
And thank you to our guests for being here today. I listened to your speeches, and there's just part of the speech that's actually in printed form. I'm just going to read out the sentence. It says, every employer, after consulting with employees on or their representatives, must issue and post a policy on sexual harassment. The policy must contain. The first one is a definition of sexual harassment, and then there's a series of points thereafter. It's actually on page 6 of my document. I'm just a little bit concerned because the way this is worded, it seems to indicate or imply that employers can actually have different types of policies that are posted. And when I think of the definition of sexual harassment, I'm a bit concerned that one definition from one employer may be different from another definition from a different employer. And my question to you is not sexual harassment, sexual harassment. That's the first part of the question. The second part is who actually monitors the actual policy that's posted to make sure that it is compliant and that one employer's policy is not so way out of line from the other employers that are also monitored or governed by this set of code. So it's a two-part question. Thank you.
Thank you. So we provide a definition of sexual harassment under Part 3 of the code. The employer's policy has to be aligned with that. So although there might be some nuances from employer to employer, they have to be aligned with what's in the code. So that's the safeguard, if you will, in that respect. Part 2 of your question is about, so how do we ensure that that they have it, and how do we ensure that they don't sort of do something else than what they're required to do? Is that sort of a fair summary of what you're asking?
Yes, it is.
Okay. So so that's part of the follow-up that we do, as I mentioned earlier. So we will do proactive follow-up. That's what we call the inspections, where we go into the workplace and we ensure that the employers are compliant with the requirements of the code. We can go in the workplace and look at a variety of things. So it doesn't necessarily mean that our visits are only targeted to the violence prevention. We might be going there for something else and look at the violence prevention at the same time. So we have those follow-ups, and we ensure that indeed the policy statements, the definitions, all of these things are aligned with the provisions of the code, either Part 3 for sexual harassment or violence prevention in Part 2. If they're not, this is where we play our education and counseling role. We work with employers. We, generally speaking, are successful through what we call an assurance of voluntary compliance, AVCs, where they voluntarily agree to comply with that. After that agreement, we will do a follow-up, or they will be asked to send us whatever has been lacking or whatever needed to be redressed.
Thank you. That actually leads to another set of questions, okay. But I just want to come back to this policy that the employers actually create. Now, you've indicated that you actually give them some parameters, so you provide the definition of sexual harassment, so that's good. But what would be the variations that you would see in certain policies between or amongst different employers? Because it looks like the employer needs to consult with employees and their representatives to come up with a tailor-made that fits their organization. So I'm just wondering if they have to include all of these different points, what would you see as a variance between one employer from another, whereas just the labor code actually just providing what's required?
I can't answer the question right now because we don't actually have a repository of all of the employers' policies and policy statement. There are almost 10,000 employers, so you can imagine the nightmare that would create for us to keep policy, and this is one regulation. So we don't have that information in terms of being able to offer a comparator.
I was just curious to know where you'd see the variations, but if you can't answer, that's fine. Going back to your concerns or your statement regarding the inspections, I know that Ms. Troopy asked some questions regarding that as well, and you'd indicated that you had made 700 inspections.
Under Part 2.
Is this, and then you also mentioned that if there's a complaint, you also initiate an inspection. But is it random inspections, or is it an annual inspection? Is it every 2 years? Do you hit the 10,000 different organizations? Like, how do you pick and choose?
So we have this intervention model that, based on this is under Part 2, so for the occupational health and safety, so the violence prevention regulations, where we identify which one are our high-risk industries, and we identify those through an analysis of data in terms of which sector, rather than employer-specific, so which sector has the most hazardous occurrences or the most fatalities or the most in that sort of scope. And based on that, we identify the top 5 sectors, and we target our interventions to those sectors. So we have, and I don't have all of them, but I could come back to the committee with a written response on that. But we have the road transport, we have longshoring, we have rail. I think there's 2 more on that. So is it safe to say that if you were not one of the top 5 sectors, you may not, this particular organization or department would never actually ever have an inspection? No, I don't think that's safe to say, but you may not have an inspection this year.
Or regularly.
Right.
You've also mentioned high-risk industries defined based on which different sectors. Why are those sectors, and you named a few, why are those considered high risk with regards to sexual harassment, not necessarily deaths in the workplace or injuries, but sexual harassment? What would define a high-risk sector?
Those sectors are defined as high risk, not specifically to sexual harassment. We don't have an identification of high risk based on sexual harassment because we don't collect data on that.
Madame Cyr, malheureusement, Madame James.
Your time is up, unfortunately, Ms. James.
Well, make a note. Okay, thank you very much.
For the high-risk industries?
Yes, thank you.
Pas de problème. Merci.
No problem, thank you.
Vous avez 7 minutes.
Thank you very much, and thank you to our witnesses for coming this morning. You can read all of these wonderful words and policies and so on that get set up, which is what you're doing as far as the labor side of it. And then it's up to employers to come to you if they're having an issue, if there's been a complaint to them, and then they can't resolve it. The 2 complaints that you said in 5 years that you've only received 2, the employer is at no time obligated to bring those complaints to you. Do I understand that?
It's actually the employees can complain to us. If the employees are complaining to their employer, because the employer in setting up the policy have to have explicitly an explanation to employees of what to do if they encounter sexual harassment in the workplace. So they would go to their employers. They do not, you're correct. The employers don't have to report back to us.
And so in the last 5 years, there have only been 2?
2 complaints, and both complaints were with respect to whether or not the employer had created a policy or posted a policy. And when we went in to investigate, we found that, in fact, that wasn't the case, that there was a policy or that the policy was posted. So that's what we mean by the complaints having not been founded.
Now, does that not concern you, given the fact that Treasury Board had told us about 29% as far as complaints that when we look on the statistics about the number of complaints of harassment, and yet only 2 got to you, got to the Labor Board? Does that not raise a concern to you that there may be a bigger problem, that somehow there's a disconnect between, the Labor Board in your program and various federal departments?
I would tell you that we make sure that we deliver our mandate appropriately and efficiently. In doing so, we live within the constraints of what that mandate is.
When was that mandate last reviewed?
For Part 2, under the Occupational Health and Safety, the last review was 2000. For Part 3, I believe it was 1980, in the mid-80s. That I don't have the specific date. I can come back to the committee with that specific date.
So it's been quite a while.
For Part 3.
For Part 3, which is the area that we're very concerned about.
That speaks specifically of sexual harassment.
And the labor code and the work that you've put together is for all federal regulated employees.
Indeed.
Right.
All federally regulated employers and employees.
Exactly. So let me ask you, has the RCMP or employees of the RCMP ever been in contact with yourselves or your department?
I would have to look into that. Specifically, they are covered under Part 2, so under the Occupational Health and Safety, they are not covered under Part 3 of the code. That's correct. Yeah.
You've indicated in the last 5 years you've only had two complaints. 2 complaints in the last 5 years, from 2007 to 2012. So I assume then that you must not have received anything directly from the RCMP, or you would have. It would have been reflective.
Well, I can assure you that for the 2 complaints under Part 3 could not have been under the by the RCMP because they're not covered under Part 3.
They're not covered under Part 3.
They're not under covered Part 3, only under Part 2, the Occupational Health and Safety. And so for that's the violence prevention, which isn't, that encompasses sexual harassment but isn't specific to it.
Yes, because I would find it difficult when you talk about violence in the workplace and then you try and tie that into sexual harassment, on how people would view that. It seems to me that your mandate really needs a very serious update to more reflect some of the challenges that we're facing out there today, specifically for women, and the whole bullying and intimidation issues that aren't violence, as you would call violence in the workplace, but their intimidation and so on and so forth. That just a recommendation I think that the committee might want to make is that you update that. Certainly it doesn't gel with the numbers we've heard from Treasury Board as to what's really happening in various departments and agencies. One of the smaller agencies that heard about had a 51% complaint, yet none of them get to you. Because that's not your role, I guess, unless the employers are going to come to you, and you've only had 2 complaints. I just find it alarming that you've only. I mean, I don't want you to have a whole lot of complaints. I like to think that the federal service was just terrific, which it is, but any huge employer is going to have lots of challenges. And there are those that are unwarranted complaints, and we all know about them, but there are lots of other complaints out there that are clearly warranted, and I think if 5% come forth with complaints, there's probably more like 8 or 9% that would, but I think people do not jump into filing complaints against their employer easily. I think there has to be very serious issues, because right off the bat you know that there's going to be an issue to do with your job future. No matter how much protection we might put down, and everything sounds wonderful in your policies, and it sounds very assuring, and it's all the right words. But we heard all the right words from Treasury Board last week, and yet there's still an alarming amount of people coming forward. And if 29% come forward, then there's another significant amount that aren't coming forward. And so it's just a bit concerning as we move forward on this and trying to create that culture where people feel comfortable in an environment, because they would be more successful in their jobs if they felt more comfortable. But you really don't cover that off when you talk about violence in the workplace.
I would say that it's hard to draw a comparison with the stats that have been provided last week, because our data is not a reflection of the whole universe, because the employers maintain the responsibility of recording, reporting, investigating on these complaints, and do not have to report back those to us. I understand your concern about the fact that we have 2 complaints under Part 3, and it looks disjuncted with.
Faites devoir vous arrêter ici, Madame.
Sorry, I have to interrupt you here. Your time's up, Ms. Scroll. We'll now go to Ms. Bateman for 5 minutes. Thank you very much, Madam Chair. And I would like to share my time between the two witnesses. And I would like to begin with Ms. McPherson.
Putting up with our little technical glitches at the start. I just want to understand first, and I always like to understand the big picture. When you have your employees, you are the chairperson of the Canada Industrial Relations Board. Now, your workplace of that Industrial Relations Board is governed by the values and ethics of the Public Service Commission, or of the Public Service, I should say, and also the rules coming out of Treasury Board as the key employer. Is that correct?
Correct. As an employer in the public service, we are subject to the same rules as Ms. Sear has described for any government department.
So your employer is Treasury Board.
The employer of the staff of the Canada Industrial Relations Board, yes, is Treasury Board.
Yeah. Okay. So you're governed by that. So then I'm just curious. You made reference to the fact that over a period of time, and I'm very curious about finding out what period of time that is, there were some 30-odd complaints, and they weren't from the harassee, but rather from the harasser. Is that what you said?
Yeah, let me be more clear. The board has to interpret and enforce the provisions of Part 1 of the Code. One of the provisions of Part 1 is what we call the duty of fair representation, and it imposes on unions the obligation to fairly represent every employee in the bargaining unit that the board has certified them for. They're obliged not to act in a manner that is arbitrary, discriminatory, or in bad faith with respect to their representation of those employees vis-a-vis their rights under a collective agreement. And I think one piece that's been missing this morning is that in many collective agreements, the union and the employer have agreed to non-discrimination, non-harassment policies. So an employee who feels they've been subjected to some kind of a harassment could also file a grievance. And the union has to take that grievance seriously and make a determination as to whether or not it should be brought forward to arbitration. The employee themselves is entitled to make a complaint to the board if they don't feel that the union has represented them properly and in accordance with the union's obligations under the Labor Code. Those are the kinds of complaints that we would hear.
Is that the 30 people that you have? Over how many years did those complaints come in that somebody thought they weren't being represented appropriately by their union?
It was over a 12-year period. I looked at the board's jurisprudence, and I was able to identify 30 cases where sexual harassment was a basis for the complaint. And so I pulled out those 30 cases.
Over 12 years, you had 30 complaints, and thank goodness you're there so that people on both sides of the complaint have recourse, as it were, and sober second thought. But over 12 years, you had 30 complaints. Now, of those 30 complaints, which ones were frivolous, or which ones were truly you felt you had to take action on? They were justified.
The test that we apply in this case, we're not looking at the merits of the grievance, whether or not there was sexual harassment or not. That's not our job. Our role is to tell whether the union
gave support,
fairly represented the employee with respect to whatever that grievance was. So we don't look at the merits of the grievance. We look at the union's conduct.
In which cases, how many of those 30 over 12 years were found to be legitimate complaints against the union?
I'd have to go back and look at the results.
Could you go back?
In a sense, that's an underreporting, because when we get a complaint, our labor relations officers will often try to mediate, And certainly if there are complaints
Appreciate,
where
Ms.
it looks
McPherson,
like...
if you could provide that response in writing. But meanwhile, I've just got a few minutes left, and I want to make sure I ask the other lady something as well. And so thank you very much. And Ms. Sear, oh, I have 50 seconds. So I just, you know what, then I would very much appreciate, you mentioned, Ms. Sarah, that you had certain percentages of work done. And you made, well, that's a part of what we do. And you made reference to education, you made reference to compliance, you made reference to counseling, and I suspect there are other pieces. If you would be good enough to let this committee know in writing exactly how your time is spent, because it would be interesting to us as we go forward, and it may be a determination as to whether or not we want to or need to have you come back, with further questions. So, c'est tout.
Vous avez écoulé votre temps, Madame Bateman, donc.
I'm afraid your time's up, Ms. Bateman. So, perhaps you could send in a written answer, and the clerk could follow up with that to the committee members. Thank you. Thanks very much. No, we're going to the other side. Ms. Ashton, for 5 minutes, please.
SDC. We heard from the Human Rights Commission last week that that one of the things that we need to see is a culture change, and that it's not enough to have recourse when people come forward with complaints, but what's important is also to make sure that we create work environments where these complaints don't take place, because sexual harassment doesn't take place. There was reference to the need for equitable distribution of power within the workplace, and recognizing that women particularly have to be in positions of decision-making and power as well. Are you involved with that kind of work? Do you see a place for that kind of work in what you do?
I would tell you that we strive through our role as legislator and regulator, that we strive to create workplaces that are respectful, where trust exists, that are safe, fair, equitable. In that respect, everything we do is aligned with that mandate.
As a follow-up to that, is there any specific reference to ensuring that women are in positions of decision-making in the workplace?
That falls outside the purview of the labor program, so I'm unable to answer specifically. The Employment Equity Act does look at the fair representativeness distribution of the four employment equity groups. And I'm sure you're familiar with the Act and what it does and doesn't do, but that would be something that's covered under by the Minister of Labour.
Thank you for that. And wasn't it that the Act for private employers was actually seeking a federal contract was actually repealed in the last number of months? Is that the partly in? I know you're referencing the General Act for public employers, but in terms of also employers that are seeking federal contracts, that act was gotten rid of.
The Fair Wages and Hours of Labor Act.
Yes. You'd be speaking to the Federal Contractors Program, I believe. Yeah. Yes, there will be amendments to that under the Employment Equity Act, but that would be a different set of witnesses that you'd need to speak with, because we're not responsible for that legislation.
I understand. Thank you.
Merci. Moi, j'avais une question.
Thank you. I have a question for Ms. Sear and Ms. Buchanan. What are the human and financial resources currently earmarked for complaints on sexual harassment? Have you any idea? And have these resources changed over the year? Do you mean that they're earmarked for this? Because the word that you use could have a different meaning. I just wanted to make sure I understood your question. I can come back with specific data broken down by year. I can tell you that approximately between 80 and 90 inspectors for Part 2, which have to do with occupational health and safety, and Part 3, which have to do with labor standards, between 80 and 90. I'll follow up with the exact data and in terms of the changes over the last 5 years. Very well. I have a second question from Ms. McPherson. Good morning. What are the current trends within your organization with the cutbacks suffered by the various departments? Have you seen a difference in your workplace?
Don't affect the work of our board because our board is responsible for the federal private sector. In terms of the nature of cases coming before the board, they tend to be relatively stable. Applications for certification. Our duty of fair representation complaints run typically at about 25% of our workload, and that seems to be consistent. I haven't seen any change in that trend.
Merci.
Thank you. 20 seconds? Okay. Okay, very well. Well, this brings to an end our the first half of our meeting. Thank you very much, Ms. McPherson, Ms. Sear, and Ms. Buchanan. Thank you very much. Indeed, we were happy to have an opportunity to speak with you. Yes, Ms. Ambler?
Through you, Madam Chair, if Madame McPherson, when you're providing the follow-up information that we talked about earlier, or that you talked about earlier, if you could give us a bit more information. I felt that after Mrs. Bateman was talking about the under-reporting, that I felt that you had maybe a little more to say. If that's something... I think that's something we might want to hear a bit more about. If, when you're providing us the other data, if you wouldn't mind.
Ce n'est pas vraiment un point d'ordre, Madame.
It's not exactly a point of order, Ms. Ambler.
Correctly, you want more information for...
Right. Yes, a little bit more information on the under-reporting as well as the other information that Madame McPherson, if possible. Just, it sounded like we wanted to... that she had a little bit more to say about that, and we wanted to hear a bit more about that, if you don't mind.
Okay. Est-ce que c'est possible, Madame?
Could you do that, Ms. McPherson?
Okay. Je vous remercie beaucoup.
Thank you very much. Okay, so we will suspend for a minute, and we'll just get our new panel in place. Thank you. Good morning again. We're going to get underway again with our second panel. So, good morning to our two witnesses. Welcome. First of all, we have Mr. Christopher Ruthman from Nelligan O'Brien Payne, which are involved with labor law and employment law groups, and Mr. Stephen Gowan. Thank you. Mr. Stephen Gowan, who is appearing as an individual. You will have 10 minutes for your presentations. Could you put your receivers on, please, your earpieces? Okay, can you hear me now? Okay. So as I was saying, you'll have 10 minutes each, and then we'll move to the question and answer period. So we'll start with Mr. Ruthman, please. You've got 10 minutes.
By way of introduction, my name is Christopher Rutham. I've been practicing law in the private sector for approximately 10 years in the areas of labor and employment law. I'm also a lecturer and professor of labor law at Queen's and University of Ottawa, and I've written extensively about human rights, labor and employment law, particularly with an emphasis on the federal public service. What I would like to confine my introductory remarks to is to deal with the question of recourse available to the victims of sexual harassment within the public service. There are, in my view, 5 essential characteristics of an effective system of recourse. An effective system of recourse must be expeditious, because justice delayed is justice denied. It must be procedurally fair, including the opportunity to be heard and an impartial decision maker. There must be expertise by the decision maker. There should be broad acceptance of that decision maker within the community. And there should be effective redress at the end of that recourse mechanism. Can the system right the wrong? In the federal public service, there are at least 5 different systems of recourse that could be used by the victim of sexual harassment depending upon the circumstances of that harassment. A victim could file a sexual harassment complaint by policy, either Treasury Board's policy or a policy in place at a separate agency or separate employer. The victim could file a grievance under the Public Service Labor Relations Act. The victim could file a complaint to the Public Service Staffing Tribunal or the Public Service Commission if the complaint refers to sexual harassment in an appointment process in the core public administration. A victim could file a complaint with the Public Sector Integrity Commissioner, or 5th, a victim could file a complaint with the Canadian Human Rights Commission. The first difficulty with this system is the sheer number of different recourse mechanisms available. This leads to confusion, it leads to overlap of functions, leads to inefficiencies because of duplication, or alternatively, passing the buck as victims are passed from jurisdiction to jurisdiction in an effort to find someone who will take control or take jurisdiction over their matter. There are also difficulties within or about each of the particular systems. With respect to a sexual harassment complaint, there are 3 difficulties that I'd like to bring to your attention. First, a sexual harassment complaint is not available to the victims of harassment if they have already grieved or attempted to use some other method of recourse. Second, there's no requirement under the policy to provide redress to the victim. The policy talks about corrective measures to address what to do with the perpetrators of the harassment, but not to talk about what to do for the victims. And third and finally, there's no requirement that the deputy head or the deputy minister agree with or implement the recommendations of the investigator. With respect to the grievance system, there are, in the federal public service, 2 categories of grievances. There are grievances that can be referred to adjudication, which is independent third-party resolution, and there are grievances that cannot be referred to adjudication that are finally decided by the deputy head or his or her delegate. Grievances can be referred to adjudication if they are about discipline or if they are about collective agreement violations. So for those employees who are represented by a bargaining agent who has successfully negotiated a sexual harassment clause into their collective agreement, the matter may be referred to adjudication, or the grievance may be referred to adjudication. For unrepresented employees or for employees whose bargaining agents have not negotiated sexual harassment clauses, their grievances are finally decided by the deputy minister alone. If the matter is not referred to adjudication, for unrepresented employees or for certain represented employees, this is not a truly impartial hearing, particularly with respect to the remedy. Is a deputy head expected to award damages or career assistance that costs money or other remedies with a financial consequence to the victims of sexual harassment when this money is going to be taken out of their budget for other priorities? And further, deputy heads have no expertise in assessing damages. They have no expertise in adjudicating. Their expertise is in management, is in program administration. It's not in remedying the effects of sexual harassment. The third category of recourse is the Public Service Staffing Tribunal or Public Service Commission. This only deals with a limited number of cases if the harassment occurred in the context of an appointment process to the core public administration, to Treasury Board. There are limited remedies in that case because the complaint is only about that staffing action. Fourth, a victim could file a complaint with the Public Sector Integrity Commissioner. However, the Public Servants Disclosure Protection Act permits the Commissioner to refuse to investigate a complaint of sexual harassment on the grounds that there is another method of recourse available. And frankly, we're in early days with the Public Service Integrity Commissioner and learning how they're going to deal with complaints of sexual harassment. We simply don't know if that is going to be effective recourse. Finally, a federal public servant could file a complaint with the Canadian Human Rights Commission. The Canadian Human Rights Commission, as you're aware, is a gateway to get to a tribunal. The Commission does not make decisions. The Commission screens complaints. Only approximately 9% of cases or complaints filed with the Commission make their way to a tribunal. And the Commission can refuse to refer a complaint of sexual harassment to the tribunal for a number of reasons. One of them is Section 41(1)A of the Canadian Human Rights Act permits the Commission to refuse to investigate a complaint on the grounds that it should be dealt with in another method of recourse. And both legally and experientially, I can tell you that the Commission routinely refuses to investigate complaints of sexual harassment in the federal public service because those victims should be going to grievance or through Treasury Board's harassment policy. Second, the Commission can refuse to refer a complaint to the tribunal if, in its opinion, an offer to settle has been made to the victim and the victim should have accepted it. So that this is a valid complaint where the Commission concludes there's merit to the complaint, yet refuses to allow it to proceed to the tribunal, instead forces the complainant to accept a settlement. The Canadian Human Rights Commission can, in many cases, be slow. It takes an average of 9 months for the Human Rights Commission to investigate its complaints. That does not include the complaints that are dismissed expeditiously because they're in the wrong forum, wrong jurisdiction, or should go to another forum. The complaints that are valid often take longer than 9 months to investigate. That does not take into account the fact that the result of the investigation by the CH, Canadian Human Rights Commission, is that the matter is referred to a tribunal, where you're looking at another 9 to 10 months in order to complete a hearing in front of the tribunal. And finally, the human rights system has the authority to grant substantial remedies for the victims of harassment, but there is one hole in that legislation, and that is that the Human Rights Tribunal has no jurisdiction to award legal costs to a victim of harassment. And that was set out in a Supreme Court of Canada decision called Mowat, involving an employee who was sexually harassed in the workplace. The tribunal awarded her $4,000 in damages, but that did not go anywhere near to meeting her legal expenses that she incurred because she retained private counsel in that case. And so the concern is that victims are not accessing these particular forms of recourse because of the flaws in them. because there's no true remedy at the end of the day, and because the expenses of pursuing the matter would outweigh any possible recovery. In conclusion, I suggest that one way to protect the victims of sexual harassment would be to carefully examine the systems of recourse to ensure that there is expeditious, effective, and fair recourse available to the victims of sexual harassment. Thank you.
Merci beaucoup, Monsieur Rotham. Maintenant, on va passer à Monsieur.
We'll go now to Mr. Gowan. You have 10 minutes. Just before that, I have the speaking notes of Mr. Gowan, but they're in English only. So they're being translated. Once we have the translation, we will distribute it. Will it be available after, when the translation is done? Yes. It's a very important witness. Thank you. Thank you, Ms. Bateman. Mr. Gowan, please go ahead. You have 10 minutes.
What I would like to do is confine my remarks to three general areas. First of all, where I fit into this process of sexual harassment prevention and resolution. Secondly, I'd like to speak very briefly about the Treasury Board of Canada's new harassment policy and highlight some differences that I see in comparison with the old policy. And then thirdly, I have some practical experience and some issues that I'd like to bring to your attention and perhaps provide some advice for the future by way of concluding remarks. First of all, I'll start with a brief description of who I am and how I fit in. I'm a lawyer by training and experience. I was called to the Bar of Ontario in 1989. I had a traditional law practice in the past, but I no longer have a traditional law practice. It now consists almost exclusively of alternative dispute resolution, or what we call ADR, and this consists of mediation, arbitration, workplace facilitation, and investigation work. I am regularly called upon to investigate harassment complaints within federal government departments, agencies, boards, and tribunals. I've investigated wrongdoing, including sexual harassment, by lower-level employees all the way up to some of the highest levels in the public service and its related organizations. In other words, I fit in near the end of the process. Once the complaint has been submitted and vetted by human resource or HR officials, once the parties have been notified, once there is a level of dysfunction already in the workplace, and once informal resolution has failed. That's where I come in. So my perspective is somewhat narrow. It's not that of a theorist or an academic. It's that of a practitioner. My investigation work is typically carried out pursuant to organizational harassment policies, most often the Treasury Board policy. As the committee now knows from hearing from Treasury Board officials, the Treasury Board just released its new harassment policy on harassment prevention and resolution, which was made effective October 1st. Now, this replaces the old policy, which had not been revised since 2001. They're similar, but there's some notable differences. And as you will see, the name change reflects one of the key features of this new policy. The formation of this new policy was no doubt a major undertaking and a positive development, in my view, to deal with harassment in the workplace. There are a number of documents and guides which I understand are still currently under development. So I think we all need to see how the policy is applied in practice before we pass judgment on its effectiveness. So let's start with the new policy versus the old policy. Like most of you, I have not had a chance to do an extensive review, but I have looked at it as carefully as I could have within the last few days. A number of related documents, as I said earlier, still have yet to be released. So I'll just highlight a couple of key features. One is scope. The new policy specifically includes harassment outside the workplace, including travel locations, conferences, training, and informational sessions. So long as these outside locations are related to the workplace, a harassment complaint can be made. Harassment definition. The difference between the old and the new is this idea that harassment can take place outside the traditional workplace. And finally, I think importantly, with respect to the new harassment definition, there used to be guides contained right in the definition itself with respect to what may or may not constitute harassment. Those are no longer there. Now, those may come out with some of these guides and other documents, as I indicated, that Treasury Board is currently working on, but I don't see them in the current harassment definition. I don't think that's a critical problem. However, it was certainly useful to enable investigators and the parties to a harassment complaint to get a better understanding of what is within and outside the lines of harassment. Managers' obligations is the third key feature that I see as a difference between the old and the new policy. Again, this may show up in some of the further documents the Treasury Board is developing, but the old policy had a section which was entitled Expectations. It discussed the expectations placed upon employees, parties to the harassment complaint, and managers. This, as I said, apparently no longer exists. One of the main features of this, which I had relied on a number of times in doing my work, was an obligation on the part of the manager to independently authorize an investigation where the manager becomes aware of alleged harassment in the absence of a formal complaint. By way of example, I've investigated a matter involving sexual harassment where the manager was accused of failing to intervene even though there was no complaint filed. I determined in that case that there had been a failing by the manager to sufficiently act upon the allegations. I hope and expect there will be a way to authorize investigations independently in the absence of a harassment complaint, and that obligation or that capacity will be given to the manager or the delegated manager. Currently, the new policy seems more focused on the responsibilities of the deputy head, as I read it anyway, rather than those of the individual manager. And again, I think we do need to suspend judgment until some of these other documents are released. Practical concerns and issues that I can bring to your attention. As I said, I'm not a theorist or an academic. I do quite a bit of teaching, and I've certainly spoken on harassment a number of times. But I don't bring to you statistics. I bring practical experience. The vast majority of investigations that I've performed have involved harassment in the form of misconduct or abuse of authority, but not sexual harassment. There have only been a handful of those. Why is this? Are there simply fewer cases of sexual harassment than we imagine? Are we now in an improved society where people better understand what sexual harassment is and how to better comport themselves in the workplace? Or is sexual harassment underreported? My answer is a bit of both. I cannot give you statistics, as I said, but I can tell you that based on the actual cases that I've investigated, incidents of sexual harassment, in my view, are probably underreported. I can think of two major investigations that I undertook that provided me with some insight into this problem. One case involved the alleged failure of a senior manager to intervene. I mentioned this earlier. When the manager became aware of potential harassment in the workplace, a number of women were subjected to alleged sexual harassment by an employee who was under that manager's direction. None of the women filed complaints. What surprised me, frankly, was based on the evidence that I gathered, it was obvious to me that each was fearful of this employee's close relationship with that senior manager. No one wanted to make waves. None of the women, in my view, wanted to be ostracized or have their careers adversely affected. Another case involved sexually inappropriate remarks and physical touching alleged against a senior male official by a female colleague who was essentially at the same seniority level. She, too, would not file a complaint. Instead, she reported her concerns to management, which appropriately authorized an investigation, and I did that investigation. She was adamantly opposed, and this surprised me. I was surprised to learn how fearful she was to come forward, even though this colleague was effectively at the same level. What also astounded me was that during the course of my interviews, including interviews with some senior women who also worked in the same office, they too experienced unwanted sexual advances and touching by the same individual, and there were others who I found out about through hearsay evidence who also experienced this. None of these people came forward. Every one of them was reluctant to come forward. So I said at the beginning part of this process that I come in near the end. What this tells me, though, about sexual harassment is that it, just from anecdotal experience, is that it often goes unreported and unchecked, notwithstanding the existence of good policy and notwithstanding the existence of good managers. So at the very end of the process, management has to decide what do we do once there is a sexual harassment complaint that has been founded. And as I alluded to earlier, there are cases where the manager has inadequately dealt with the situation. I believe that too often there is an ineffectual follow-up once the investigation is completed. Now, I know this committee is concerned with recent allegations of sexual harassment within the RCMP. I've looked at the RCMP policy. I undertook an investigation which did not involve sexual harassment, but involved harassment alleged harassment against some RCMP officers. I think they have a good policy. At least the policy that I have with me today is from 2008. It's actually much more specific and, in a sense, broader than the Treasury Board policy. It creates some really compelling obligations on management, on the employees, and on the parties to an investigation, and yet apparently we still have problems. So as I said earlier, you can have good policy, good managers, and still have problems. Thank you.
Je faisais signe qu'il restait une minute.
I was telling him that there was a minute left.
I would like to leave you with three main points. There needs to be better education and training in federal workplaces on the issue of harassment in general and sexual harassment in particular. In general, people need to better understand that unsolicited and unwanted sexual advances are not acceptable. People also need to know that they can safely bring forward their complaints without fear of retaliation or adverse impact on their careers. Second, we need to make sure that managers can and should be able to independently authorize investigations where the situations warrant it in the absence of a formal complaint. And thirdly, where serious allegations of sexual harassment are proven to be founded, there needs to be an effective follow-up by way of action in restoring the workplace and consequences for those who have breached the policy. Thank you.
Je vous remercie beaucoup.
Thank you very much. Thank you for your interesting presentations. Before we go to questions, I must make a correction. Some committee members who feel the need to talk about sexual harassment, not necessarily between from a man to a woman, but perhaps the other way. So just to clarify that the harassment can work the other way as well, from a woman to a man. We'll go now to the questions. Ms. O'Neill-Gordon, 7 minutes.
This is for being with us today. You certainly gave us lots of interesting facts and facts that we're glad to have here in our study. And now I'd like to ask you, what can you tell us about how the federal workfare plays in comparison to the broader Canadian workplace? We know that you brought lots of practical experience in different areas beyond just the federal workplace, and I'm wondering just how this compares to the broader workplace with regards to frequency of sexual harassment and how complaints are addressed in other areas as well as to the federal area.
I'm not sure who that question is for, but I can perhaps jump in.
Both of you, really.
Okay. I can jump in and tell you that I think, in my view, the federal government and the provincial governments have been incredibly progressive in bringing in harassment policies and legislation to deal with this problem. It's almost like it doesn't exist in the private sector. You very rarely see sexual harassment complaints. In fact, you very rarely see harassment complaints. And when you do see them, my experience is they're not generally dealt with adequately.
Certainly in terms of internal mechanisms to deal with harassment complaints, the Federal Public Service is significantly better than the broader public sector or the private sector. One of the main differences is in the federal public sector, there are a number of internal mechanisms, harassment complaint under policy. You can file a grievance. There are other administrative methods of recourse. In the private sector, you're stuck with either a human rights complaint and hope for the best with that, or in some cases a civil action if the sexual harassment has other components to it aside from just being sexual harassment. If it is in a federally regulated workplace, you cannot sue for sexual harassment alone, but you could sue for constructive dismissal on the basis of the fact that you were sexually harassed.
Okay. I'm glad to hear you say that it's more of a positive and that both the provincial and the federal governments are taking a more active step towards preventing this and having more of a study, and people feel they know that this is available for them to look into anything that they need to complain about and bring forth their complaints. Now, we've already heard from the Treasury Board, and I'm glad to hear you say that this new policy is more of a positive step in the right direction, that an informal approach to addressing complaints is often taken to address complaints,
And can this be an effective approach when it goes in that direction?
Well, I can give you my experience perhaps as a mediator and tell you that informal resolution is often very effective. It really depends on the nature of the complaints. And I know that it sounds like on the surface all sexual harassment complaints are the same. That's not the case. There are degrees and there are different cases. So I would suggest that informal resolution, including workplace facilitation and one-on-one mediation, can be very effective and usually resolve the problem if it's handled properly.
That's all true. I just also want to say that there are benefits to resolution outside of the informal resolution. There's informal resolution has both the benefit and the detriment of being confidential. There's no publicity around promoting people coming forward with sexual harassment complaints if it's done by way of informal. There's no broader sense of deterrence in adverse publicity if it's dealt with through an informal mechanism. And so there are a large number of benefits to resolving sexual harassment complaints informally as soon as possible. But I would not like to see a system where there is no access to a more formal complaints mechanism. There are real benefits to having a decision that's made public at the end of the day.
I can maybe give you a quick example of a case that I'm working on right now, actually, and I offered up mediation to the parties. It's not a sexual harassment case. It's simply allegations of harassment. But I will tell you that one of the responses you often get from the respondent is, I want to be vindicated. So sometimes people do need that closure, and the same applies to complainants. They need a definitive decision at the end of the day sometimes. So that varies from case to case.
Mm-hmm. And how do you see the private sector becoming more educated and more ready to take part and file complaints and be more upfront than what they are right now? Do you see any ways that we can that they can be trained and made feel comfortable with this?
It's difficult to see how that can happen until we as a society perhaps become better educated. We can see, for example, organizations and companies taking more of a progressive stand in trying to prevent harassment in the workplace. I've seen that.
Yes.
However, we cannot compel the private sector to put on, for example, mandatory sessions to train them as to what does or does not constitute harassment. Often it's a financial issue. They don't want to put the resources into it. I'm glad to see that the federal government is putting the resources into trying to prevent it in the workplace, and hopefully there'll be some trickle down to the private sector. I expect there will be.
To follow up on that about whether we can mandate...
No, I know we can't mandate, but I'm just wondering.
No, I'm saying we can.
Oh, we can.
You can mandate training on sexual harassment. We do it in Ontario for workplace violence. There's requirements that employers over a certain size, and the size is pretty small, have to train their employees in workplace violence and workplace harassment. And as an employee in the firm in which I work, I recently attended the Government of Ontario's webinar that we all had to sign off that we had attended, and it was fantastic. So there are things that governments can do to require better education in the private sector.
That's,
Second.
10 seconds. We'll go to the opposition. Ms. Hazenia, 7 minutes. I just wanted to tell you that I'll be sharing my time with Mr. Caron, my colleague. Question for Mr. Caron. The workplace culture has a direct impact on sexual harassment. If you look at the cases you've dealt with, could you identify the factors that might help prevent sexual harassment in the workplace?
But I would say to you that often when you have a hierarchical system where there are perhaps more men at the top of the chain rather than women, you can have that kind of thing exist. In one case that I did handle, there were a number of senior women in the office, but the most senior person was a male, and he was the manager who was accused of not dealing appropriately with allegations against a colleague. So I would say to you very simply that there does need to be a cultural change. There's no question about it. And I think the movements we've made towards a more equitable workplace, where there are more women in senior positions, will be helpful.
Donc, si je comprends bien, s'il y avait plus de...
So if I understand correctly, if there were more women in positions of authority, you think there would be fewer cases of sexual harassment?
I will tell you this, though. For whatever reason, perhaps even the majority of cases that I've investigated that involve harassment have been allegations of one woman making a harassment complaint against another. And that's really just through anecdotal experience. I can tell you that. There's certainly no statistics to back it up. So I think you may be right. You may see fewer cases of sexual harassment. I'm not sure you would see fewer allegations of harassment in general.
Est-ce que monsieur, l'autre même, vous avez quelque chose à ajouter?
Would you care to add to that, Mr. Eltham? Thank you. Mr. Eltham, at the last meeting of the committee, we heard from the Human Rights Commission, which said there was a lack of direction and policy having to do with leaving the workplace when the victim files a complaint, unless they take sick leave, which isn't ideal. How are the victims of going to get out of the workplace, which becomes very unpleasant for them?
Is very sparse for that sort of thing. In the core public administration, this is the Treasury Board employees, they're governed by the Public Service Employment Act, which does permit the deployment of a manager who has been found to have harassed his or her subordinates. Aside from that deployment, which takes place at the end of an investigation, there's no legal way to deal with it unless you're going to administratively suspend someone, probably with pay, during that process. Anecdotally and from my experience, I can tell you it's sick leave. The victims of harassment, they're either left to fend for themselves, or there's some informal mechanism put in place that moves them to a different position, or they're at home on sick leave. None of those things is the best solution.
Est-ce qu'il y a des mécanismes dont vous...
Are there any procedures you knew of that could improve the atmosphere in the workplace? If there's a sexual harassment complaint, the situation becomes very difficult for the victim. So have you got any recommendations as to things that could be done to make things easier for the life of the victim in the workplace while the complaint is being studied, of course, besides taking sick leave?
Things that can be done, but I have to say that each of them would have to be contextual, that there's no one solution that's going to fit every single circumstances. Some of the things that can be done are to change the reporting relationship between the victim and the alleged perpetrator of sexual harassment. Another thing would be to move one or the other of them, but there would have to be some element of voluntariness to that move. It's not fair to force the victim of sexual harassment to change jobs simply because she came forward with a complaint. Likewise, it's not fair to the alleged perpetrator to damage usually his, career by forcing him to move into a different role or a different managerial position. There'd be a stigma that attaches to that. And so I don't think there's a one-answer-fits-all questions to that point. You have to look at the context. You have to look at the nature of the workplace. You have to look at how serious the complaint of sexual harassment was. And you have to look at whether an attempt at immediate informal resolution of the problem has already been attempted and failed.
So what you're saying, actually the question I would be asking in that sense then is, should we maybe have a set of options available rather than right now, which seems to be some kind of a void in that regard, once again, beside having a sick leave? there doesn't seem to be, I mean, and as the tribunal said, that there doesn't seem to be any policy or guidance regarding this. So should we have as a recommendation to actually develop a set of options that would be available in the case where there is an ongoing case, an ongoing complaint?
Yes, I believe a set of options would certainly be helpful. Whether that's done by legislative change or requires legislative change depends on the types of options that you're looking at. A lot of them would be simply changes in policies or practices within the workplace.
Okay. Mr. Gahan, quelque chose à rajouter sur le sujet?
Anything to add on the subject?
Echo my colleagues' comments and say that there are certain things you try to do when you have very serious allegations, whether it's sexual harassment or another type of harassment, one of which is separating the parties. So if that's feasible, that's usually a good idea, and that doesn't always happen. But I agree that a set of options would be certainly helpful, and it needs to be decided on a case-by-case basis.
Merci.
Merci. On repasse.
Thank you. Government side, Mr. Husband, 7 minutes.
Welcome, gentlemen, to our meeting this morning, and thank you for your contributions. I'm just, Mr. Rotham, you mentioned that there were many options available and perhaps too many options available, and this would be confusing to complainants. I wonder, could you, would you have any recommendations in that area as to how that process can be improved?
I would have one recommendation at least, which would be to make sure that there is some forum for complaints where complaints will be accepted, will be addressed, and that the victims of sexual harassment will receive the redress that is necessary or appropriate in their case. There are a number of different ways that could happen. One way it could happen would be to clarify the jurisdiction of adjudicators under the Public Service Labor Relations Act. You remember I said that some grievances end up with the deputy head, other grievances can be referred to adjudication. A guarantee that a grievance that alleges a breach of the Canadian Human Rights Act, including sexual harassment, would be dealt with by adjudication instead of being dealt with solely by the deputy head would certainly help resolve that, a lot of that confusion, and would ensure that there is a forum for redress for the victims.
Good. Could you, would you mind submitting that recommendation in writing to us?
I can do that.
Okay. Second question I have is, Mr. Cohen, you had three significant, what you termed significant points, recommendations, and the third one I noted you indicated would be adequate follow-up, and I just wondered if you could possibly elaborate on that a bit for us.
I think that's essentially a human resources issue. So the policy, as it's currently drafted, speaks in generalities, as did the old policy, as to what should happen after an investigation is completed. But from my experience, what I found out from speaking with HR managers after an investigation is completed, that very often there's very little done. I'm not really speaking specifically of sexual harassment cases, although in the one particular case where there was a failing on the part of the manager, there wasn't a whole lot done. So what can be done? Well, this is, as I said, is a human resource issue. I think the federal government needs to take, or I should say the public service needs to take strong steps to make sure their HR managers are properly trained and make sure that where situations warranted, for example, there's progressive discipline, which doesn't always happen.
Okay, and if I may, Madam Chair, and this maybe would be to either one of you two gentlemen, could you possibly, how would the Canadian approach in this situation compare to approaches taken in other countries? Do either of you two gentlemen have an experience with this situation in other countries?
I'm going to pass this over to my colleague here and see if he's got some information.
No, I haven't looked carefully enough at how this is done, dealt with in other countries.
Okay. Okay. That's my questions, Madam Chair. Thank you. Couple
Vous avez
minutes.
terminé? Okay.
Very well. We'll go to Ms. Grohl for 7 minutes.
Mr. Guyan and Mr. Rimmer, thank you so much for your information today, because it starts to really give us a handle from people from the outside that deal with this. I mean, we can hear all kinds of departments, but we're hearing the real stuff from both of you as far as the kind of work you do and what you've actually seen. I have to say that I have great faith in our country and in our public service at all levels, because I think we're way ahead of a lot of countries. But be ahead all we are, we still have significant issues. I mean, I don't think you can, if you don't change the culture of the environment that people are working in, impossible on how many rules. I mean, the RCMP's 2008 that you referred to, it's great policy. They got huge problems, and so do many others that are facts that are underreported for a lot of reasons. And I'm not sure the policies are going to change that. It's more to do with the culture and the training that we can do. And I think the Federal Public Service is an example of putting all kinds of things in place, but we still have the problem. So until we change the culture of organizations, I'm not sure we're going to be able to solve some of these issues. I like your comments on those.
I'll start by saying that I agree with you. I think training is very important. I don't believe that there's mandatory instruction currently available or being, I guess, that employees are compelled to take mandatory training for to understand harassment in the workplace. I'm not sure that's the solution, that it be made mandatory, but I think it certainly should be strongly encouraged. In other words, there should be seminars available from inside or outside providers to employees to understand how the new Treasury Board policy works, to give you one example, or if you're within another organization that has its own policy, they should be taught to understand how those policies work. They should understand generally what does or does not constitute harassment, and they should certainly be made aware of what is acceptable and what is not acceptable in the context of sexual harassment. So I think those efforts can be made, and they can be made stronger. However, there's a point that I'd also like to add, which is we have to be careful not that these policies are not used as a sword instead of a shield. And you do see that happen. You see that happen in sexual harassment cases, and you see it in regular harassment cases. So we need to be conscious of the fact that if we're over-promoting the policy, sometimes you encourage bad faith or frivolous complaints.
And I agree with you that a cultural improvement in the public service would be helpful. But echoing comments made by Mr. Gown earlier, the Federal Public Service is generally seen to be good at this. There is broad acceptance that sexual harassment is inappropriate in the workplace, particularly in the Federal Public Service. And so I don't think we need that big of a culture change. What the culture change that would need to happen, if we can call it this, is the culture of how complaints are dealt with, or whether complainants are marginalized for bringing complaints, and frankly, whether it's worth their while to bring a complaint. If a complainant is bringing a sexual harassment complaint, it takes 4 months to do an investigation properly. At least. So let's say 6 months after the complaint is filed, there's an investigation report. The deputy head gets the investigation report, delegates it to the ADM of HR. The ADM of HR decides we're going to take some appropriate action. It's been 9 months later. The victim of sexual harassment has just been through 9 months of investigation while they've been on sick leave, moved out of their unit. And great, there's been a finding of sexual harassment. The perpetrator has been reprimanded. Why did you do that? As a complainant. Complainants are thinking, why would I have gone through all of this just to receive some element of vindication? That's enough for some people, but it's not enough for everyone, and it's part of why these types of complaints are underreported. So if you're going to change the culture it can't be sexual harassment is bad. The culture has to be complaining about wrongdoing is good.
You don't want to open the door for frivolous complaints.
No.
And I can suggest to you that for someone to come forward and complain of sexual harassment, I'd like to think 99% of the time, that took a tremendous amount for that individual to get to that point. I don't think there's frivolous, I don't want to think that there are, but we all know that there would be I'll say a 1%. But it's getting women to be empowered enough, and I say women, but I'm not sure it's just only women we're talking about, not in the new world that we live in. But it's the whole issue of empowering those individuals to be able to literally push back to the manager, be able to take things more into their own hands rather than feeling like they're a victim. There should be the mechanism for a much more upright, straight-on complaint, and that complaint gets resolved. And either the manager is moved or instructed in a better way of handling these issues, rather than a woman having to feel like she's a victim for this long period of time. It's the empowerment of women as well to be able to come forth with these things in a much more straightforward manner. I mean, I know they're underreported. We know that. And as women who have worked in the workplace all our lives, we know it's underreported because nobody wants to get into that. You know, it's not something that I think women want to go out there and start reporting it. It is a minimum of 9 months. And so it's not done lightly. And yet many of them just would prefer to quit their jobs and find another job where they're not going to have these kind of difficulties. That happens a lot. You must hear it in your work.
Yeah, I tend to agree with you, and at the risk of reducing my own workload, I will tell you that investigations are an unhappy and unsatisfactory process. They're usually, and they ought to be, the last resort. I think you can probably accomplish a lot by involving the parties at an early stage where, let's say, if you're speaking about women, they feel comfortable enough to come forward and know that it could be resolved perhaps informally. Very often, at least in the cases that I've encountered, these women simply want the actions to stop. They're not looking for blood. They're not looking for vindication per se. They're not looking for anyone to get fired. They're simply looking for the wrongful acts to stop, and it can often be resolved at an informal level.
And I agree that they're not looking for vindication, but for recognition that there has been something wrong. I have been a victim of sexual harassment. Somebody in power recognizes that.
Would you both make...
Je m'excuse, Madame Screw, vous avez...
I apologize, Ms. Screw. I'm sorry, but your time is up.
Recommendations following today's meeting to the committee on the kind of things that the actions that could be taken that would improve the situation.
Est-ce que nos deux témoins acceptent de...
Would our two witnesses agree to making some written recommendations for us along the lines suggested by Ms. Groh? Would that be all right with you?
Very general recommendations and material that I've provided to you already, but perhaps Mr. Rutham and I can coordinate our efforts, and I'll certainly be happy to discuss it with him.
That'd be fine.
OK. Donc, Madame la greffière va faire un...
So the clerk will follow up with you. We'll now start into our last 5-minute period, and we go to the government's side. Ms. Young, 5 minutes.
Again, I'd like to reiterate and say thank you so much for coming today and providing us with the information that you have provided, which is very startling and interesting. I'd like to ask, following up on what Ms. Scrow was asking, are there any sort of immediate recommendations that you feel, given your extensive expertise and experience in this area, that the government can do, or put into place that would have some very positive impacts? Mr. Goen, for example, just at the end here, you said that maybe an earlier sort of an informal mediation process would be highly effective in terms of giving an intervention opportunity before things got too unbearable at work in those circumstances.
Well, that's correct, but I will tell you this, those provisions are already there in the policy. They've already been in the old policy, and I'm sure you will find those provisions that require early intervention and early informal resolution in virtually every government harassment policy. So really it's a question of educating people and making sure that they understand, particularly HR directors or those responsible for managing the process, they need to understand that those options need to be pursued vigorously at the outset.
So is this then an education training aspect for those senior managers who are in positions of authority or positions of decision-making where they can pull the members in and say, if this continues, your job is at risk, or those kinds of things, to informally set the tone and correct these incidents in the workplace?
Yeah, I absolutely agree with that. And in fact, where I've found that there's been, failing is probably too strong a word, but a lack of adequate action on the part of a manager, it's usually because they have not intervened promptly at the outset. And I agree that that is a training issue. I think that managers need to be trained in this area and understand that earlier intervention will generally be effective.
So, in fact, is it correct to say, and Mr. Ruthin, please feel free to jump in here, that in our deliberations about changing the culture, whether it's RCMP or the federal workplace or even the dribble-down effect in the business community, because we heard earlier that, in fact, there were private businesses and et cetera that aren't covered by the federal policies, et cetera, and you're probably aware that our federal government has initiated a Women on Boards initiative in our last budget, $5 million to support and put more women onto boards so that they're in as another aspect for this dribble-down effect in the private sector. So getting back to my question then is if, in fact, the managers who are in these positions of decision-making are held more accountable or are better educated and trained about this aspect, that would have a huge impact, given that we already have these policies and programs and processes in place for, who knows, at least a high percentage of these incidents to be addressed in this kind of informal way?
Obviously, I can't speak to a number of the initiatives that you've mentioned because they're so new, and we don't have any data yet about whether they're going to work or whether they're working or not. In terms of some of the things you mentioned are better education for managers. Some of the education that needs to happen is to allow managers to better recognize sexual harassment when it's happening in front of them. This isn't just about training people not to sexually harass. There are, quite frankly, a small number of people, but a number of people who are just never going to get it. And the training that would be most effective would be to train their managers to recognize that this is happening, act proactively instead of waiting for a complaint to materialize. When a complaint does materialize, to deal with it quickly and effectively, not necessarily punishing the perpetrator, but to deal with it in whatever way is appropriate. And then if we can't do that, then sexual harassment is going to keep happening, in which case we have to find a way to create a proper remedy for the victims of sexual harassment, to make sure that they're willing to come forward and to make sure that their careers are put back on track.
May I just ask you to go a step further, though, and put out there the fact that it's not only just the manager's role to recognize sexual harassment, because sometimes it's behind the scenes or on coffee breaks or lunch. It's not in the workplace. Perhaps it's up to them to create a work environment where people feel comfortable approaching them about this kind of thing, right? Because they're not always going to be in a situation where they see it. And that reporting or the fact that the employee feels comfortable doing
Madame Young, votre temps est écoulé, alors une réponse.
Your time is up, so a very quick answer, if we could.
I think I have anything further to add other than to say that your suggestions are certainly valid.
Thank you.
It's the same.
OK. Je vous remercie beaucoup. Alors, c'est...
Thank you very much. This brings to an end today's meeting. I would like to thank our witnesses, and I wish you all a very good day. Thank you.